This session covers the issue of recognition of entities that claim to be states. We are looking into the relevance of the reaction of other states of the international community when they are faced with the emergence of a potential new state. I will start outlining what we mean by recognition of states in international law, then explain how it is manifested and its consequences, including a brief reference to the main theories outlining its relevance in international law. I will finish with a reminder on the obligation of non-recognition that is derived from potential breaches of peremptory norms of international law that can be involved in the emergence of a new state. As a preliminary consideration, it is important to highlight that recognition is informed by political considerations, and as such, it defies general principles of law that demand similar consequences for similar situations. Because recognition is mainly a political decision and is used as a political tool, the way in which states behave is inconsistent and depends on the specific situation. We will see multiple examples to illustrate this point. Recognition is a unilateral act of a state acknowledging that a new state is accepted as a sovereign equal in their international relations. The act by which a state recognizes another state is profoundly political and on many occasions not directly related to any objective criteria. States might decide to not recognize a state even if it is clear even if its existence is clear and cannot be denied. For instance, the Arab states do not recognize Israel. When this happens, the impact is less perceptible in the non-recognized state. In other words, the consequences for Israel of not being recognized as a state by other states are less profound, let's say, than the consequences suffered by Kosovo for not being recognized by a sizable number of states. The question of recognition is only relevant for disputed or new states. Once a state is well established as such in the world states, the issue loses relevance. There is no question about whether or not or who recognizes the United Kingdom, India, or Morocco, for instance. Therefore, the topic of recognition is relevant when a new entity claims to be a state and wants to be recognized as such. Recognition, I remind you again, is mainly a political act, but the legal implications of recognition are significant at international and domestic level. Think, for instance, about recognition of passports, privileges and immunities of states, the functioning of the postal services, the acceptance of currency. Even buying something online will be impossible if you try to carry out the transaction from a country that is not recognized by other states. I repeat, recognition is a unilateral act by which states accept a new state among its peers. It is a discretionary act. States are free to recognize or not recognize, with the only exception of situations deriving from a breach of international law that are peremptory norms, something I will refer to again a little bit later. They are also free to decide when and how to articulate that recognition. Recognition can be explicit through a formal statement addressed to the public at large or addressed directly to the concerned state. For instance, I have reproduced here several official public statements recognizing Kosovo that were made by the United States of America, Senegal, Turkey, and Australia. Recognition can be inferred from the treatment given to a new state. For example, establishing an embassy and full diplomatic relations in another country is considered a form of recognition of that state. This is not the case for consulates. Becoming a party of a treaty to which another non-recognized state or territory is also a party is not a form of recognition. States not recognizing Israel, for instance, often insert a clause when ratifying a treaty to which Israel is also a party, reminding that becoming a party of that treaty does not imply recognition of Israel. We have seen some examples of this when we examine declarations and reservations to treaties. The practice of states demonstrates that the states can also withdraw their recognition, something that emphasizes the political character of these declarations. So if we look into Kosovo, for instance, some states that had recognized the country previously have later on withdrawn that recognition. This seems to have been, for instance, the case of Sierra Leone. Over the years, many states who recognized the Saharawi Republic have also frozen or suspended that recognition. Obviously, the different means in which recognition can be granted or even withdrawn may lead to confusion. I am reproducing here a tweet by the Minister of Foreign Affairs of Jamaica from February 2020, where she is forced to clarify a former tweet by the President of Kosovo explaining that Jamaica had not recognized Kosovo, contrary to the claims of the President. In principle, only states can recognize other states. However, international organizations play a very important role in consolidating or weakening the position of a new state. I want to highlight that acceptance by an international organization as a member will many times have implications in terms of the recognition of a state as such. First, international organizations make decisions through votes of its state's members. When states vote in favor of the new member, some level of recognition of the new state is implied, because many international organizations are only composed of states. Being a member of the international organization means being a state member of such organization. Therefore, supporting a new member is supporting the membership of a state. Also, consequently, the relevance of the membership in an international organization in terms of recognition will be less significant if the organization accepts non-state actors among its members. If the organization accepts non-state entities as members, it is obviously more difficult to derive any implications in terms of recognition. Becoming a member of the same organization where another non-recognized territory is a member does not imply recognition. This is the case, for instance, of the membership of Taiwan and China to the World Trade Organization. It does not imply recognition of Taiwan by states that do not recognize this territory as a state. Still, the World Trade Organization uses a very specific language to refer to Taiwan, calls it Chinese Taipei. Particular relevance is attached to the membership to the United Nations, because it requires a great level of endorsement by the majority of the states of the international community. In addition, the United Nations has competence over virtually every topic field of international law. And finally, only states can be state members of the United Nations. A state that wants to become a state member of the United Nations needs to request it before the Secretary General. Then it requires a positive vote of 9 out of 15 members of the Security Council, including no veto by the permanent members, the 5 permanent members of the Security Council. And then if it overcomes that challenge, it will require the endorsement of 2/3 of the General Assembly votes. The relevance of membership to the United Nations can be illustrated with the example of Palestine. It was unable to secure membership to the United Nations due to the veto of the United States. However, it was aware of its numeric support among other countries of the international community and decided to attempt to become a member of UNESCO, which is a specialized agency of the United Nations where veto powers don't operate. Once it became a member of UNESCO, this move, among others, increased the pressure for accepting Palestine in the United Nations organization. Finally, it was agreed that it will be accepted as a non-member observer state. The immediate effect of recognizing Palestine as a state by the United Nations, even if not a member, involved that Palestine could ratify a wide range of treaties, including most controversially the Statute of the International Criminal Court. I am not going to enter the discussions that surround this issue. However, I want to highlight that decisions to accept as a member of an international organization a state in its quality of a state have important implications that go well beyond whether or not states members of the organization individually recognize the entity as a state in the reciprocal relationships. To recap, membership in an international organization does not imply that the states of the organization recognize that state as a state. Again, Israel is not recognized as a state by many other members of the United Nations. However, membership to the organization involves recognition of a statehood for the purpose of the organization. In the case of the United Nations, as seen in the case of Palestine, it can also trigger a radical change in the capacity to establish international relations with other states and international organizations. Therefore, in principle, recognition is always a unilateral act of states. In practice, international organizations are recognizing de facto disputed states, and this can have important implications in reinforcing or weakening their statehood claims. States have accused others of recognizing a new entity as a state too soon, especially when there is no clear control over the full territory. It is claimed that early recognition of statehood can easily involve interference in domestic affairs of another state, or it can exacerbate a conflict because a new state doesn't come from thin air, but mainly from detaching from another state that is usually not agreeing with the secession of a part of its territory. For instance, these allegations have been made against Germany for deciding to recognize Croatia and Bosnia when a large part of their territories were still under Serbian control, and more importantly, breaking the common policy that the European Community, today the European Union, was adopting in relation to the conflict in the former Yugoslavia. In these scenarios, recognition is clearly used as a means of supporting a claim of independence that has not been completed, and stands against the enemy they are opposing, in this case, Serbia. Certain conditions can be attached to the recognition of a new state. Obviously, states can maneuver to seek recognition as part of a more or less problematic transaction. Withdrawal can also be the result of more or less obscure diplomatic operations. I have already said that several states have withdrawn the recognition of Kosovo or the Saharawi Republic, many times under rumors of pressures or deals concluded with Serbia or Morocco, respectively. Sometimes recognition seems to hide cases of straightforward corruption. For instance, in 2014, the former Guatemalan president, Alfonso Portillo, admitted to taking bribes from Taiwan in exchange for continuing to recognize the country diplomatically. When we talk about the legal nature and effects of recognition of states, it is normal to find references to the so-called constitutive and declarative theories. According to the former, the act of recognition is necessary for a new entity to become a state. There is no state without recognition. Another formulation of this idea, articulated for instance by Christian Hilgruber, defends that states are not born by recognition, but chosen as a subject of international law. Only when the new state has been recognized does it become a subject of international law, and this initially only with respect to the existing states recognizing it. On the other hand, the declarative approach to recognition explains recognition as a formality, an act that acknowledges the existence of something that already exists. Accordingly, positions adopting the declaratory approach will defend that a state exists if it meets the criteria for statehood. As we have seen, these are a territory, a population, and an effective government with capacity to enter international relations. In practice, references to both theories are made very often, but have very little significance. The geopolitical interests in forming recognition defy neat theoretical frameworks. Let's look into this and other issues covered in this session through different examples. Let's start with an archetypical case to explain the topic of recognition of states, the breakup of the former Yugoslavia. Firstly, a bit of background. This is the map of the former Yugoslavia as the state established after the Second World War with 6 federal states. Serbia had 2 provinces that acknowledged their ethnic differences, one for Kosovo with a majority of Albanian population and one for Vojvodina, a multi-ethnic region with a substantive ethnically Hungarian population. Slovenia and Croatia declared secession from Yugoslavia in June 1991, followed by Macedonia a few months later. During the first months of 1992, Bosnia and Herzegovina also voted for independence, igniting a full-blown civil war. In April 1992, what was left of the former territory of Yugoslavia, that is Serbia and Montenegro, formed the Federal Republic of Yugoslavia, renamed in 2003 as the State Union of Serbia and Montenegro. With the independence of Montenegro in 2006, the Republic of Serbia is also born. From the moment Slovenia and Croatia declared independence in 1991 and the armed conflict started, the European Community, what today is the European Union, and its member states became intrinsically involved in the evolution of this conflict and the future of the former Yugoslavia. The initial declarations of the European states made clear that they would have preferred to preserve the unity of the former Yugoslavia. However, the events left no choice but to adopt a position on recognition or non-recognition. They could not, as they did when Kosovo declared its independence for the first time in 1990, just ignore the issue. At the same time, decisions on recognition had a very important impact on how the conflict evolved and its outcome. The fundamental role of the European Community and NATO in this scenario demonstrates the transformational role that international organizations play today in international relations. Therefore, the European countries belonging to the European Community work together to adopt a common policy and react to this conflict from its inception, and were very heavily involved throughout the peace process. From the start, they operated under the premise that a common policy would mitigate the impact of the conflict. 2 main events are particularly relevant in our context. First, the creation of the so-called Badinter Arbitration Committee in reference to the French member who presided this commission to arbitrate among the Yugoslav authorities involved in the conflict. Its decisions were not binding, but of great relevance in the peace process. Second, the approval of the declaration of guidelines on the recognition of new states in Eastern Europe and in the former Soviet Union. The European Community guidelines that the state members agreed to recognize new states imposed de facto conditions that go well beyond the requirements of a population, a territory, and an effective government. Recognition became conditional to the respect of democracy and human rights, the respect for the rights of minorities, the reaffirmation of the principle of inviolability of all borders, understood as uti possidetis juris, unless agreed otherwise, a commitment to disarmament and to the peaceful settlement of disputes. On the other hand, the Badinter Arbitration Committee issued 16 opinions of great relevance for the final outcome of this process. They touched on fundamental issues regarding self-determination and territorial integrity, among others, but we are now here only interested in the topic of recognition of states. Its first opinion adopted a declaratory approach to the recognition of states, recalling the Montevideo criteria for statehood. The Arbitration Commission also declared that the former Yugoslavia had been dissolved and lacked international personality, and while it was adopting a declaratory approach to recognition, it also acknowledged that recognition involved some rights and duties of the recognized entity. The European Community state members also adopted a common position on conditions to be met by the new states created as a result of the breakup of Yugoslavia. Basically, they had to express their wish to be recognized as a state and meet the criteria established in the guidelines on the recognition of new states in Eastern Europe and in the former Soviet Union that I have just outlined. These conditional recognition guidelines worked in different ways. Germany decided to unilaterally recognize Slovenia and Croatia in December 1991, breaching the collective management of the Yugoslav situation by the European coalition. The effort to have a common policy and recognize all the new independent states at the same time resulted in other inconsistencies. Slovenia probably fulfilled all the criteria for recognition since July 1991, but was not recognized by the European Community member states until April 1992. On the other hand, Bosnia and Herzegovina was recognized at the same time, April 1992, but it was still largely under Serbian control. The reality of the practice of states makes evident the impossibility of fitting in any general theory approaches to recognition. We can find entities that seem to meet the criteria of statehood and with very limited international recognition. However, that lack of recognition does not prevent them from operating at some level or at different levels as states, with also different levels of capacity in international relations. I have used here to illustrate this point the countries, the flags of Northern Cyprus, Taiwan, Somaliland, and the Republic of Abkhazia. The reignited conflict over Western Sahara demonstrates that even if international organizations and a big number of states recognize a new state, in this case the Saharawi Republic, it may not be enough to consolidate their position in the international arena. A reminder here that is explained in further detail when we look at the topic of international responsibility of states, that the states are obliged not to recognize situations that are the consequence of a breach of a peremptory norm of international law. In this area of recognition of states, again, the role of the United Nations, the Security Council has reinforced this obligation for specific scenarios and has approved this, resolutions by which it made illegal the recognition of some territories as states, for instance, in the case of Northern Cyprus, Rhodesia, Namibia, or also in relation to the invasion of Kuwait when it was occupied by Iraq. In its Kosovo advisory opinion, the International Court of Justice recalled that declarations of independence might derive from the breach of a peremptory norm of international law, and this implies the obligation of non-recognition of such a situation. And finally, non-recognition does not equal tyrannious or lack of responsibility for internationally wrongful acts. A non-recognized territory is not open to occupation. Equally, depending on the specific situation, breaches of international law within the territory with a disputed status will have to be attributed according to the rules governing international responsibility.